Dear colleagues, greetings. Today, on the 6th of December 2025, the advisory group of experts gathered in full to conduct the interview with the candidate for the position of the judge of the Constitutional Court of Ukraine, Anna Mostetska. In particular, all six advisory group expert members are present. Secretary Maureen O'Connor, members of advisory group of experts Yaroslav Romaniuk, Mr. Aleš Zalar, and Vasil Shakun. Also, Hanna Sukhotska and me, the chairwoman of advisory group of experts, Oksana Vasilchenko. Also, during the interview, four deputy members are present. This is Vitaly Makhinchuk, Mr. Volodymyr Kuzmenko, Mr. Richard Barrett, and Mr. Thomas Griffith. I note that we work in a shelter, so in the event of the air raid, interviews will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live on the advisory group of experts resources on the website of the Constitutional Court of Ukraine. Therefore, I draw the attention of the members of advisory group of experts and the candidate to the restriction of the use of sensitive data and information with limited access live. If it's necessary to discuss such issues, the broadcast will be stopped. We are ready to begin, and I give the floor to the Secretary Maureen O'Connor for a brief introduction of the candidate and a reminder of the interview regulatory framework. Please, Maureen. Дякую.
The public who is watching this morning or today. As Ms. Vasilchenko has already said, the advisory group of experts will now conduct an interview with the candidate Mostetska. Let me remind you that the interview is a mandatory stage in evaluating candidates and assessing their compliance with the criterion of high moral qualities. Our one interview is given approximately up to 1 hour, and the time limit for answering questions is up to 3 minutes. Traditionally, we ask all candidates to be concise and answer clearly, unambiguously, and to the essence of the questions asked. At the end of the interview, the candidate can make a short final statement, no more than 5 minutes. I would also like to note that during the processing of materials about candidate Mostetska, the advisory group of experts sent her questions to provide written explanations, so the candidate has had the opportunity to prepare and to provide answers. So I will briefly introduce the candidate. Ms. Mostetska is a judge at Ternopil City District Court of the Ternopil region. For the past 6 years, she has served as a judge speaker. She is a trainer implementing services for vulnerable groups of court users at the EU project Pravo Justice and the National School of Judges of Ukraine. At Ternopil City District Court, where the candidate works, she organized the implementation of the Court Volunteer Service of Ternopil City District Court, a social project where volunteers assist court visitors in every possible way, helping to find courtrooms, providing vulnerable persons with information about the premises available in the courthouse, offering emotional support, caring for children, etc. She also holds the status of an attorney at law. Ms. Mostetska, if you want to add something to your background or the information that I have just mentioned, you can do so now for up to 3 minutes. If not, we will commence with the questioning.
Thank you so much for the introduction. I don't have any additional statements. Dear colleagues, we will get to the interview. Ms. Hanna, please. Yeah.
Madam Mostetska, we are starting with the question. The first question concerning the funds for the apartment given to your son in 2021. Starting in 2021, you declared an apartment of 80.6 square meter in Ternopil, which your mother-in-law gifted to your husband on 27 September 2021. You and your family members have been living in this apartment since 1st September 2023. The mother-in-law purchased the property according to an investment agreement dated 21st March 2017. Do you confirm this information?
Yes, I confirm.
According to the State Register of Individual Taxpayers, your husband's parents received a total of Ukrainian hryvnia, 64,745, roughly about $13,000, before taxes for the period 1998-2025. Of this, after 2008, your husband's father received roughly US dollar 1,250, while your husband's mother had no income. You also provided copies of documents showing that between 1st May 2015 and 6 April 2016, they received monthly pension payments of approximately about US dollar 50. And now is my question. From what sources did your husband's mother manage to save in US dollar about 25,000 for the purchase of the apartment? Please, it's my question to you.
Thank you for the question. I want to inform dear members of advisory group of experts that parents of my husband, they never lived with us. We lived separately. Speaking about funds for the purchasing of this apartment, I have provided in the process of communication copy of banking investments. One of them that was kept about the presence of funds that the parents of my husband had. Parents did not work at the public office. They didn't work in law enforcement or in judicial system. At the same time, they are experts in their domains, and it allowed them to work. And until this day, they're working without special labor documentations and agreements. So these questions, this is not the sphere of my responsibility. However, this income allowed them to make savings, and the sum of these savings was sufficient to purchase this facility.
Do not provide details about bank account deposits and the amounts for which the property inherited by your husband's parents was alienated.
Here we talk about documents that could have been formed in 2010, 2009, 2008. That's the plan when my mother-in-law and her husband, they had a bank investment in the bank Hreshatik. At the same time, this bank was liquidated, and to receive these documents about the origin of the funds, there's no opportunity. I have provided only that agreement that was kept and those receipts that were kept. Unfortunately, other documents that could prove this sum of money, I don't have it, unfortunately.
Such a different response from you, but when responding to the advisory group's question about whether your husband's mother had sufficient funds to purchase this property, you initially stated that her bank savings were equivalent. You gave the same explanation to the High Qualification Commission of Judges in 2023 during the qualification assessment. However, after the advisory group pointed out that as of the date the funds were withdrawn from the hryvnia deposit in 2009, the dollar equivalent amount should have been considerably lower, approximately 13,000. You revised your explanation. Why did you give conflicting information about the dollar equivalent of your mother-in-law savings in the bank of March 2009? Did you intentionally exaggerate this amount? Because now we have to verify what was exactly in the past, because there are the different sums. You explained about it. So please give maybe more detailed information.
Since these were not my funds, and I was guided by the explanations that mother-in-law has provided to me. Maybe I did not clearly explained in my first explanations that the sum in $20,000, so this is the general equivalent of the sum that they have received in that year. At the same time, documentally to prove, I can prove only the sum by the equivalent for $13,000.
Yes, please. No, sorry, because your husband's parents constructed a residential building measuring 205 square meter, Petrikiv near Ternopil, between 2008 and 2010. According to the technical passport dated 19 February 2010 and your declaration, its value was about 75 US dollar. It is noted that during the same period, your husband's mother withdrew funds from a bank deposit on 24 March 2009. Does this suggest, it is my question, that these funds were not used to acquire the aforementioned apartment as property, since the withdrawal from the bank deposit was due to expenses for building a house in the village of Petrikov? From what sources did your husband's parents manage to save up 75 US dollar for the construction of the aforementioned house?
I want to say that 75,000 US. This is for the technical inventory of the building, which was conducted later after the construction of the building. This building was built before the time when we were married, and from the explanation of my husband and his parents, I know about the fact that this house was being built for many years with the strength of parents of my husband and thanks to their hard work. So they did not cover the expenses to the sum that it was assessed by the technical inventory. Also, I know that the building was already built and it was ready for living when the mother-in-law, she was taking out money from the deposit. She converted into currency in order to make savings.
Your information are not very clear, because when providing explanation to the High Judicial Council in High Qualification Council in 2023, you mentioned that the house was built at the expenses of your husband's family. We asked you the same question, as AG, and you initially answered the same way, but later indicated that the residential house was also built with your husband's income, who at the time worked in the quarry, as you said, yes, and had the opportunity to purchase building materials at a preferential price. So now is the question, why does the information about the persons who incurred the cost of building a house in Petrikiv provided by you to advisory group contradicts to one you mentioned earlier? And how did your husband bear the construction costs, considering that according to the State Register of Individual Taxpayers from 2003-2010, your husband's income before taxes were approximately about 4,000 US dollar. So as you see, that all the information not very coherent. Please.
Thank you for the question. Thank you for the clarification. Maybe there are certain discrepancies that happened because I didn't know my husband and his family at that period of time, and this information was given to me in the process of my questions that as I was asking. At that moment, my husband lived with his parents, and jointly they were building this house at the plot of land that was purchased earlier in 1998. So this construction was took a long time, and it was difficult to separate who spent how much time how much money they spent for the construction of the building. They explained to me, my mother-in-law, my father-in-law, and my husband, they explained to me that there was the sum of savings that parents of my husband had as a result of their labor, as a result of their received heritage, as a result of their unofficial work. Also, my husband, at the moment, he was a young person. He could physically work a lot. He worked at the construction site. He also had the income. Speaking about declaration or no declaration, unfortunately, I cannot give any more explanations because this was not the sphere of my responsibility, and all these events happened before I got married with my husband.
For the public, you have to be a judge in the Constitutional Court for the public. I think that when we put together all the sum, 25,000 US dollar to purchase an apartment in Ternopil, and then 75 US dollar for the residential house near Ternopil, it looks like very strange. And then the total officially confirmed incomes of your husband are exactly sufficient for making these two investments? It is a general question. Even if your husband, as you said, worked very hard, but the money are needed.
Thank you. I understand. However, I want to pay attention to the fact that a lot of time passed.
At the same time, please consider a lot of time passed. This is about what happened in 2009, 2010. Since 2010, I am married to my husband, and regretfully, I cannot find any documents or confirmations that would confirm my words. As for the building and the cost of the building, I would like to say that its value was assessed by the expert when it was finished. The expert did not take into account for how long did it take to build the building, when the money was invested. He has just assessed the overall value of the building at that time at market price, as I understand.
Діяльності. Під час попередніх письмових раундів ми вам вже задали.
Shall we move to the questions about your professional activity? During the previous written rounds, we have asked the question about the resolution of 5th October 2018, which was about the case of Article 130 of the Code of Ukraine of Administrative Offense, in particular driving transport vehicles in the condition of alcoholic intoxication. You have closed proceedings before the end of the 3-month term for holding a person liable in the administrative way. Do you remember which case was that about? According to the opinion of outside observer, when reading the text of the resolution, there could be an impression that I closed the proceedings on the case when the term of holding the person liable in the administrative way did not expire. However, by chronology of this fact, this resolution was placed in 2018. Of this fact, it became known to me in the year 2019 from the comments from the Public Council of Integrity during the qualification assessment. Immediately, I have checked the materials, and during verification of such materials, I found improper fulfillment by my secretary of the court session of his professional duties. For this reason, I informed the head of the staff about such a fact and requested internal investigation. As I could remember, after 1 year since this decision was made, I identified the following. This resolution had to be placed as 10th of October 2018, and in the text of this resolution, I have made also a mistake, an error. In that case, a court session was appointed 5th of October 2018, at the same time as I did not have any notification about the date of the hearings. That hearing was postponed till 10th of October 2018. In the materials of the case, due to negligence of my secretary of the court session, such notifications did not take place, which has actually was the reason of such a mistake that nobody noticed from my office, as well as court employees, unless it was emphasized by the representatives of the Civic Council of Integrity. If that error could have been identified during my authority, it should have been corrected by setting the proper resolution about correcting this mistake. Yes, we understand the fault of the secretary. We cannot agree, however, that it was just an error, because the date of the resolution, 5th of October, this could be the error. Yet, in the text of the resolution, indeed, the calculation of the time frame of statute of limitations, also the wrongful term. Two mistakes in one document, how could you explain? This could be explained by the workload. I admit that the mistake was made. This matter was discussed in the process of my qualification assessment. A huge workload at that period of 2018. I was investigative judge. In addition, we have reviewed the cases on the administrative offense. All of the materials have been reviewed by 3 judges. And also I was involved in the participation of collegial cases, which required a review by the panel of 3 judges. According to my estimates and the judicial statistics in that period, incomplete period of 2018, I have made put into the Unified Registry of Judicial Decision over 3,000 documents. And here simply it was the circumstance that the mistake was made. I'm a specialist in the field of law. I have been a judge for a long time. I understand the responsibility of myself, and intentionally I would never commit such a gross violation of the norms of material and procedural law. It was simply the error. Yes, indeed, your understanding is correct, that this is about honesty and integrity of your professional activity. In particular, the advisory group paid a lot of attention to such facts. It was quite scrupulous, and the requests were made to Ternopil City District Court, and the replies of the court have been received. That in the automatized system of document management of the court, the information of cases distributed to you as of 10th of October are absent. I can explain as follows. A lot of time passed since 2018. I did my best to find out from the head of the staff and technical employees in which way do they record such dates of meetings and whether such information can be recovered. I was explained that this module of subsystem electronic court was updated many times. The functionality has changed, and recovering that information, which took place back in 2018, is no longer possible. Due to it's a process of the communication, I provided all possible documents in order to confirm that the judicial review of this case indeed took place on 10th of October, and on 10th of October I have made the relevant decision. The advisory group of experts is carefully reviewing all materials of the case. And having studied, having examined the information that you have provided, in particular the journal, handwritten journal of review of judicial cases and materials by yourself as a judge as of 10th of October 2018, where this case was mentioned, and other 12 cases, On one hand, this journal is not official document which could disprove. And again, we refer to the reply of Ternopil City District Court following our request, which has confirmed that this is a form of internal control and cannot confirm any requests. At the same time, from amongst all 12 cases that have been defined on 10th of October 2018, for any of them, judicial sittings have not been appointed on 10th of October. This is confirmed by the reply of Ternopil City District Court. The question is, how could you explain this? In the process of communications, when I was asked a question about such cases recorded on the 10th of October in the journal of registration, only then I understood that those cases have not been reviewed by myself on 10th of October. I thought that that question was resolved already during my qualification assessment. Yet when I examined all those matters, I looked into my old diary, and I found that indeed those cases have not been appointed on that day. And after that, verification from the internal database, document base confirmed the same. On 10th, I have reviewed, I was involved into 2 cases. One was about the criminal allegation of a number of persons. It was a collegial case. It was planned for a long time. And this case, which is now in question, as was the secretary of the court session, I would like to understand myself how this journal is kept and how could I confirm my words. I was explained that there are 2 types, 2 ways of maintaining this journal. Either the records are put of all cases which are turned in to the office of the court in order to follow the progress of the case, or recorded the cases which are appointed on this particular day, and then in more detail they put the marks about the progress of the case. In the material of the disciplinary proceedings and the findings I have received and which I have examined, I found it became understandable to me that the secretary of the court session did not follow the same line in maintaining the journal. She maintained the journal inappropriately, and actually, in the conclusion, they have recorded that there have been notifications about the case on the 10th, and they have formulated the court notifications, and copy of the materials was not added to the materials of the court proceedings. As time passed, I can recover that chronology. I can only confirm with the documents which I provided already to the advisory group of experts. I understand that such documents are absent in the materials of the case about summons of the party. Yet the court has a register of outgoing documentation. Also, the court could not confirm that there was the registry of such judicial summons. I would like to note that this was back in 2018. Our court reviews 30,000 cases, and the registry of postal mailings with recordings in the database was the innovation. Only for the last half a year, one can surely trace such mailings when they have been shipped. Back in 2018, such a system did not exist. The paper journals have been used by employees, and over time they have been destroyed. For this reason, neither I can provide them, and the court also cannot provide them. I cannot provide them because in the possession of the court, such documents are absent. The case of 5th of October, according to the case materials, had to be reviewed. The parties did not arrive, as you explained, for some reason, and postponement of the case from Friday the 5th to Wednesday the 10th. Was it sufficient to notify the parties that they had received the documentations about summons to court? Does it correspond to a general time frame when you summon the parties? If they don't arrive on Friday, on Wednesday you can say the party was duly informed about the time of the hearing of the case. Usually, it does not correspond to the practice. However, it was the end of my authority on the judicial review of cases and materials. On 17th, there was expiration of my term of authority, and my schedule was rather intense and was busy with collegial cases, as the colleagues did their best to complete the review of cases where I still could participate. And for me, just 10th of October was free to appoint the case. This term corresponds to the norm of the Code of Ukraine or the administrative offense, according to which a person will have to be notified about day and time of hearing the case in 3 days. Normally, we don't do it because we understand the practical implementation of this regulation, that it takes more time for the mailing shipment, and the recipient receives it from the post office, and the postal shipment returns back to court, which and it could be connected, it could be added to the case materials. At the same time, this time frame followed the law. In the material of case, why did I postpone from 5th to 10th? There was no mailing notification. I expected that over this period of time, the mailing notification will return. And also my professional ethics, I had the case which I had to complete. My authority is about to end, and transferring the case to my colleague, which stays with no mailing notifications, I believe to be wrongful. Therefore, it was appointed on 10th of October. Did you commit any activities, or do you think that there is a procedural capability to correct that mistake, which was committed back in 2018, when you have repeatedly appointed as a judge? Did you have procedural capability, and whether you have used such a professional opportunity to correct that mistake? Yes, indeed, I had opportunity to correct the mistake, yet I did not use this opportunity because I believe that this matter was resolved during my qualification assessment to the position of the judge of Ternopil City District Court of Ternopil Oblast. I have looked at that moment and I decided to keep the situation as it is. Madam Hanna, your questions, please.
Problem with my voice. Okay, now I have some questions concerning your integrity, declaration of integrity. By the order of the head of the Ternopil City District Court of Ternopil region, dated of 7 July 2010, you, then a court consultant, were reprimanded for breaching internal labor regulations. When questioned by the advisory group, you stated that disciplinary action was taken against you for being only 30 minutes late for work. Do you confirm the information? Why did you not reflect the relevant fact in paragraph 22 of the Declaration of Integrity of the Judge for 2016, submitted for the first time in 2017?
Дякую за запитання.
Thank you for this question. Filing the Declaration of Integrity and Family Relations was quite new for the judges, and there was no detailed explanation of how to file such declaration at that time. I have missed this moment, and I did not include the relevant information in the Declaration of Integrity, which was filed for the first time, and accordingly it became the mistake, the derivative mistake. At the same time, when filing the documents for participation in the selection for the position of the judge of Ternopil City District Court, I notified the High Qualification Commission about these facts. In the material of my file as a judge, there is information of being held liable for violation of internal rules, of which the order was made in the year 2010.
Before and after, including on April 27 of that year by a decision of the Ternopil City District Court, where you worked at the time, your future husband, with whom you were probably already acquainted, was recognized as having the right of ownership in an authorized construction, the house in Petrikiv we just talked about. And on 30 August 2010, approximately a month and a half after you were brought to disciplinary responsibility, you resigned from the court. Now question, could an objective observer get the impression that the reprimand for being late by 30 minutes after 7 years of work in court and the subsequent dismissal a month and a half later might be linked to the decision made in the case about the house in Pitrik where you then moved in? Because you can tell that 30 minutes is exactly not such a problem.
Дякую вам за запитання. Я погоджуюся, що на думку стороннього спостерігача можна так проінтерпретувати ті події.
Thank you so much for the question. Yes, this is how events could be interpreted in 2010. But everything happened in a totally different way. The decision to resign from the court was planned ahead of time, and the implementation was a long-term decision. When I had enough experience in the law domain, I had enough experience, I appealed to the chair of the court with the question, is my career of the judge possible in this court? He said this is not possible because there are difficult procedures, and he advised to look into other domains of law. I want to remind you that all these events happened prior to the first judicial reform, before first transparent competitions where candidates could apply. I decided to realize myself in the defense lawyer sector, and I decided to switch. I had enough experience, and for the first time I referred to the commission with the application in 2009. I was refused to be accepted to take my documents because of the different interpretation of the fact what experience is needed for the particular position in the sphere of law to pass this exam. And second time, I appealed to the Commission with the application in March of 2010. And then in July of 2010, if I'm not mistaken, in the summertime of 2010, I
Ні, я
No, I'm talking I'm not talking about resignation. I'm talking about the stage of when I passed the exam to become the defense lawyer. The first stage I successfully passed in July, and then my supervisor was notified about the fact that I have intention to pass the exam, and I'm planning to resign from the court. Speaking about disciplinary measure. It seemed like this violation was insignificant, and I'm the worker with the long years of experience in the court. Supervisor could have looked at this situation in a different angle. But here we need to take into account that the chair of our court and the chair of the apparatus, they were very, very requiring. And this mistake led to disciplinary reprimand. Truly, I was late. I wasn't right. I did wrong. This is not a permissible action. And when I passed these exams, we had a small town at that time, and colleagues, lawyers knew that I'm going to leave the court and I'm going to search for a new job. Probably I will work as a defense lawyer, and they offered me to go through the interview to work in the limited liability entity, and I successfully passed the interview. It was in August month. And from the 1st of September, we agreed that I will start working there. And starting with the 1st of September, I started working, and then I finished the exam to become the defense lawyer because I needed the certificate. And I want to pay attention that if I could have done the action which would have a negative effect, this would be portrayed on my further career, because reputation, especially in a small town, it's very important. I would not be hired to this job where I received the salary, which was 3 times more than I had before. They wouldn't have allowed me to pass the exam to become the defense lawyer. So practically here, there was the following situation. Besides that, when I took part in the selection process for the judge in 2012, about this fact in my application, I notified the High Qualification Commission. There was a small period of time from the moment when the reprimand was entered into effect, and there was the verification of this fact that happened because there was the special verification that was appointed for all candidates, and Commission did not identify any facts that would have undermined the opinion that I am the candidate with integrity. Так, ви мене чуєте? Вибачте. Ви мене чуєте?
Так, чую.
Yes, we can hear you. Дякую.
Explanation. Thank you so much, because as I know, you have finished your explanation, yes? Your answer to the question. Thank you.
Так, я поясню.
Yes, I have explained. Thank you. Anna Andreevna, let's move to the period of time that you have just now was talking about, that you were talking about your activity as the consultant at the enterprise and how you worked as a defense lawyer. So during the interview, you said that it gave you opportunity to receive a salary which is 3 times more than the previous salary. Did you receive? No, this was official salary in the limited liability entity. Speaking about lawyers' responsibility, I can explain right now about this period of time. Can I talk about my incomes? Yes, this is what we want to talk about. We want to talk about incomes from the lawyer's activity. Yes, I started working at the enterprise where the scope of work was much smaller than I had it before when I worked in the court. However, the payment was much higher. I had enough time for my self-development, and I received the certificate of the defense lawyer, and it was a long path to receive it. I planned to develop as a defense lawyer. However, I was not sure, and I did not have enough experience that I will be a good specialist in criminal proceedings, because in the court I didn't have such experience. Before I worked with civilian cases more. That's why I wanted to be working. This was the analog to the free of charge legal assistance. During taking these turns, defense lawyers, usually they are young, who don't have enough experience, they were appointed to do certain procedural actions with persons who were accused in criminal proceedings. And at this period of time, I had in my accompaniment the range of cases which allowed me to achieve this experience in criminal specialization. At the same time, I had the case. This was the proceedings in Kozivsky District Court of the Ternopil region, and then Ternopil Appeal Court, where the participants of the case, these were relatives of my friend. I was working on the basis of the power of attorney. I did not receive any funds for that because this was the request of my close friend, and they were taking me to this court trial sessions. It's not far from Ternopil. It was 40 kilometers away. There was needed, the vehicle was needed for me to deliver me to the sessions. So practically, from the defense lawyers' activity, I didn't receive any money, and I did not declare them. At that moment, I had a good salary, and I could allow myself to work with the permission of the supervisor to develop in this way. Anna Andreevna, and as you have given the written explanation, your husband right now is not providing, he's working at the main work of, at the same time, according to the Unified Register of Advocates of Ukraine, your husband worked as an attorney from a particular enterprise. How can you explain these discrepancies? Did you know about the fact that your husband worked as an attorney? Especially after this question, you probably appealed to your husband with the explanation. He said that with this enterprise, he is attached with the agreement to provide legal services. According to this agreement, his expenses were reimbursed, and the client needed the result to pay for the costs. That's why my husband did not break the agreement with this client, and he does the services in this case. As much as he explained to me this case, even though it lasts for a long time, however, this case is not closed yet because there were court trials on appointment of expertise that court needs to solve this dispute. And probably the last session happened just recently. We're talking about two cases. First case lasts since 2023 until now. Your husband, he is composing procedural documents. There are certain expenses for trips to the court. I think there were special construction expertises were conducted, and there are many other cases as well. In two cases, he works free of charge. At the moment, free of charge, but these services are not free of charge. He explained that by the agreement, the cost of the services is envisaged. I gave this agreement as a proof, but funds were not paid. They will be paid by the client later. And this is related to one situation where there was the dispute with the enterprise. The first case related to the assistance to compile the documents. Second is the court trial. So this is one agreement which right now is not fulfilled by the side of my husband. That's why payment has not been carried out yet. Thank you, Anna Andreevna. I don't have any questions. Dear Yaroslav Mikhailovich has the question. Dear Anna Andreevna, according to your declaration for 2023, your husband alienated the vehicle Mitsubishi Court for 40,000 hryvnia, which, according to the official course of hryvnia towards US dollar, is $1,053 USA. When we get to the profile website where there are allocated all the advertisements on the sales of vehicles, the similar vehicle was the cost was $4,000 US dollars for the vehicle like that. So the price was too low. The question is, since funds from the realization of this vehicle, the funds came to the budget, your family budget, why the price was so low? Maybe your family tried to optimize the taxes, or maybe, secondly, your family tried to promote, to help the seller of the owner of the vehicle to go through the financial monitoring, during which he would have to reason the legal aspect of the origin of the funds that he had to provide for the for the ownership. I will explain. The cost that seems to be too low, it's related to the fact that this vehicle was right after a car accident. I was the driver. I was with my older son when we stood on the crossroad. The other driver didn't choose the right speed. He hit the vehicle which was behind us, and this vehicle hit our vehicle. Mitsubishi Colt is a small car. Do you have a documental confirmation? Have you provided these documents to the advisory group of experts? Yes, I did. The order of the administrative liability of the person, about the insurance reimbursements. Okay, thank you. Thank you. Okay, good. Another question. You took part in the competition to become the judge of the appeal court, but after practical exercise, High Qualification Commission made decision to suspend your participation due to the low result. You didn't agree. You appealed the decision of the High Qualification Commission to the Cassation Commission, and they took your administrator, together with that Qualification Commission, appealed in the appeal procedure to the Supreme Chamber, but there's no decision yet. But if we can model the situation and the Supreme Chamber will confirm the legal aspect you will have the decision to continue the competition in the appeal court. Where is your priority? Where do you want to work? Why do you take part simultaneously in two different competitions? Explain to us, please. When there were posted and published points for the practical exercise, I was very surprised to find out that I lacked. The question is about your priority. That's what I was trying to ask. You're trying to take part in two competitions at once. What's more important for you? Where do you see yourself? I just wanted to give more explanation, but I'll be brief. The lack of points to the position of the judge of appeal court, it gave me opportunity to look at my career in a broader way and assess my legal achievements and where I want to move further. By all means, for me, the priority is this competition and the position of the judge of the Constitutional Court of Ukraine. I think this is the top of the lawyer's profession. So this competition is the priority. I am right now in the procedure. The procedure in the appeal court is frozen, so I think it's exhausted concerning me. For me, this has already stopped. Thank you. I do not have any more questions. Vasil Ivanovich, Anna Andreevna, I have a question. Can you tell me, you have explained here that one of the sources of income for your husband was the work in the quarry as the construction man. On the other part, he is the attorney and he presents the interests in the courts, interests of certain companies and enterprises. I am interested, where exactly does he work and how does he pay the taxes? Officially, he is employed in the company Pratera, position manager. He stopped the attorney's activity. He has one only client left, and he's working now officially at work at the position of the manager, sales manager, as a sales manager. Sales manager? Yes. So how does he present the interests of the company without having official competencies? In courts, for example.
How does he represent the interests of the company unless he has official authority, at least in the courts? He did not stop his activities as a lawyer, as a practicing lawyer, and his main job is to finalize a case which is still pending. Dear colleagues, unless you have questions to the candidate, Anna, you have 5 minutes for the final statements. Dear members of the advisory group of experts, first of all, I would like to thank for your time, attention, and the level of the discussion. I'm grateful for the opportunity to present my vision, to hear the comments and answer the uneasy questions. Thank you very much for your questions and for the high standards that you guide every candidate to. To me, this is an honor to be here. The Constitution of Ukraine is both the fundamental law and the basis of the societal contract which formulates the state. This requires a dialogue with the society, and the norms of the constitutional law should be the basis for decisions which are implemented every day for the rights and liberties of people. I started my professional career when I was 19, and every year of my activity was devoted that the law is not just abstract and the justice is not the word and is experience. My everyday activity is empathy, ability to to hear the people, to know the values, and also the hard work day to day to protect the rights. Over these years, I learned how to work in the uncertainty, war, pressure, to find a balance between the letter and spirit of the law, take decisions that will sustain criticism and time. I don't avoid complicated challenges, and they have strengthened my professional position. My experience in the court, analytical work, as a speaker's activity, as a lecturing activity helped me to develop the systemic vision. This is critically important for the Constitutional Court, public speeches, volunteer initiatives, working with young people. All that taught me to communicate the complex thing in a simple way. I believe that the Constitutional Court requires both specialists and people who can speak the language of trust. My motivation is simple. I would like the Constitution to be not a formal text, but a live benchmark for the state, which is fighting for its freedom. And I'm ready to absorb the responsibility for that. Thank you for your trust and attention. Dear colleagues and the public, thank this the interview of the advisory